Good morning, everyone. This is the April 27, 2021 meeting of the Charlotte Zoning Board of Adjustment, and is now in session. I am Patrick Welch, the chairman of the board. Also sitting with us today is Ms. Christy Long, Mr. Douglas Wilson, Mr. John Floyd, Mr. Raghu Kota, and Martha Wilson. Marshall Wilson, I'm sorry. Also present, we have Mr. Shad Spencer, our zoning administrator, Ms. Lisa McCarthy, planning project manager, Terry Hagler Gray, senior assistant city attorney, Ms. Jill Sanchez Myers, senior assistant city attorney, Max Oliver, clerk of the board, and Atkins Court reporting, verbatim reporting. All right, I would like to start by acknowledging that we will be conducting this meeting using a remote electric platform. This is the 11th remote meeting of the Charlotte Zoning Board of Adjustment, and I would like to ask you for your patience today as we proceed, because there may be some slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statute and the Charlotte Zoning Ordinance, and we conduct evidentiary hearing on requests for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that will be taken to ensure that each party due process rights are protected, and we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by the North Carolina General Assembly in Session Law 2020-3 that allows the remote meeting in quasi-judicial hearing during declaration of emergency. Second, each applicant was notified before being placed on today's agenda that this meeting would be conducted using a remote electric platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on this request using this remote platform. Third, notice of this meeting was provided to the applicants and the public in a number of ways. Notice of today's hearing was mailed to the property owners within 300 feet of each subject property and notified the property owners of the remote electric platform, and the letters also stated to contact the city immediately if there was any objection to the case being heard on today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notices for today's meeting contain information about means by which the public can access today's proceedings. Finally, any individual wishing to participate in today's evidentiary hearing were required to sign up prior to today's proceeding. This information was also included on the board's website. Hearings are applicants for a variance for the regulation in the zoning ordinance, application for the variance for the regulations in the zoning ordinance, application for a variance for this regulation in the zoning ordinance. The order of the recommendation agenda would be as follows. The zoning administrator or a zoning staff member will identify the case and recommend approval of the variance with any recommended condition based on specific reasons. The chairperson would ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard on a later date. The chairperson will ask if the board has questions, staff, or if there are any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the agenda will be as follows. All parties who plan to give testimony, pro or con, must be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicants present their testimony for the case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits will be required to be provided to the clerk no later than 12 p.m. on Monday, April 27, in order to be considered at this hearing. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for purposes of this hearing and can only accept sworn testimony. While the board would not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another at a quasi-judicial hearing on the zoning and land use matters. All applicants should have been provided with a copy of the advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of the property owner and have not received a copy of the opinion, please use WebEx platform function to message the clerk of documents. The document will be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such a request at the start of that case. Appeals from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board written decision in which to appeal, in accordance with North Carolina General Statutes 160A-388E. In order to receive a written copy of the decision, any aggrievance party must file a written request for a copy of the board decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of this case. Everyone, please remember to mute your microphone when you do not intend to speak. You will hear 4 cases today, all of which would be recommendation agenda items. The first case, 2021-025-2617 Osmond Street, presented by Lisa McCarthy. Clerk of the board will read the names of anyone who opposed the case. With all those who plan to give testimony today, affirm the below.
Lisa and I will be sworn in at the beginning, so if you'll do that. Yeah.
Again, with all parties who plan to give testimony today, affirm the following. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do. And Chairman, it looks like Deborah Dryden has joined and she's a regular member. So I know we have 2 alternates that are also sitting. So I guess one of those would come off and then Deborah would sit on. So either Raghu or John, either one of those. So it's up to you.
Okay, no problem.
If we can just confirm who's going to sit for the first, well, for the cases, it looks like, so it would be yourself, Douglas, John Floyd, Krista Long, and then Deborah Dryden.
Okay.
I think those would be the 5 for this, for the cases.
Okay. So for this case, we, again, myself, Ms. Dryden, Ms. Long, Mr. Wilson, and Mr. Floyd. Correct. Okay. Lisa, please present the first case.
The first case is case number 2021-025. It's a residential setback and rear yard variance. The applicant is requesting 2 variances to construct a single-family home on a non-conforming vacant lot from the setback and the rear yard allowance. And I'll give you a couple minutes to look over your findings, and Chair, if you'll just let me know when you've had enough time to review.
Okay, we can proceed.
Government Exhibit Number 1 is a vicinity map of the subject property. Government Exhibit Number 2 is a zoning map of the property. The property is zoned R4 single family and is surrounded by other R4 single family properties. Government Exhibit Number 3 is an aerial map of the property. Government Exhibit Number 4 is a close-up aerial map of the property. You can see the property is vacant with some vegetation. Government Exhibit 5 is background of the subject property. There was previously a single-family home on the property, and it was demolished around 2010. This left the property vacant. The lot was created prior to 1989 and is approximately 5,114 square feet, which doesn't meet the 8,000 square foot minimum lot size required in the R4 zoning district. Since the lot predates the current zoning requirements and does not meet the minimum lot size, it meets the definition for a non-conforming vacant lot. The lot is permitted a single-family detached dwelling if the setbacks, yards, height, and parking requirements are met. Government Exhibit Number 6 is the variance request. The required setback for the property is 30 feet, and the required rear yard is 40 feet. The lot ranges from about 76 feet to 80 feet in depth, so the application of the required setback and rear yard leave a permitted building depth of about 6 to 10 feet, which you can see over on the left. The applicant is requesting a variance of 10 feet from the 30-foot setback to allow a 20-foot setback, and a variance of 20 feet from the 40-foot rear yard for a 20-foot rear yard, and that'll permit a building depth of about 36 to 40 feet to construct a home on the property. Slide number 7 is considerations. Staff supports the requested variance. The hardship results from conditions that are peculiar to the property due to the lot size that's smaller than other lots in the area, because most are around 11,000 square feet. Without a variance, the permitted building depth would be about 6 to 10 feet. The requested 36 to 40-foot building depth is consistent with other homes in the neighborhood, and you can see that in the bottom right. They range from about 35 to 50 feet in depth. The hardship didn't result from actions taken by the applicant because the property was purchased in its current configuration. The applicant's act of purchasing the property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. Granting the variance will not alter the character of the area. There was previously a single-family home on the property that was demolished in around 2010. And finally, granting the variance will not impact public safety. Government Exhibit Number 8 is a photo of the property. The property is currently vacant with some trees and vegetation. And that's the end of my presentation if you have any questions for me.
Are there any questions of staff at this moment? Do we have anyone who's wanting to speak for this variance at this time?
I'd like to say something. Hello?
Ma'am, are you willing to give a testimony on this?
Yes, I live in the neighborhood.
Okay, ma'am, can you give me your name and your address?
Penny Welsh, 1125 Bethel Road.
Okay, ma'am, before you give testimony, I have to swear you in.
Okay?
Okay. Do you,
All right.
do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes.
Okay, you can go ahead.
Um, at this point, I would suggest that you pass the variance. The property has never been maintained for 5 years that I've lived in the neighborhood. It's a unsightly piece of land. I think the only other way of rectifying this problem would be selling it to the person on the corner at Fordham, which I think initially the property was attached to. The other question I have, though, is would this set precedents for any other corner lots in the Westover Hills area?
I can speak to that. Since this property was subdivided prior to current regulations, it would not set precedent. It's an existing non-conforming lot that's was created prior to our current regulations.
Okay, thank you.
Do we have anyone else who's willing to speak in opposition of this variance? Does anyone on the board willing to pass a motion that we approve this variance?
I move to approve the variance. This is Douglas Wilson.
I have a move by Mr. Wilson to approve. Do I have a second?
Second by John Floyd.
I have a second by Mr. John Ford to approve this variance. We'll send it to a roll call vote. Mr. Wilson,
Wilson, yes.
Mr. Floyd,
Floyd, yes.
Ms. Dryden, Mr. Floyd.
I voted yes already.
Okay. Okay, Ms. Dryden message yes. And I yes. So the
Mr. Chair,
Mrs. Long?
Long as yes.
Okay, thank you. So I have a yes by Mrs. Dryden, I have a yes by Mrs. Long, yes by Mr. Wilson, yes by Mr. Floyd, and a yes from myself. So the variance has passed.
Mr. Chair, the board needs to address the findings of fact that were proposed and take a vote on the findings of fact.
Does anyone see anything that needs to be changed within our findings and facts?
I make a motion to accept the finding of facts as written. Dryden.
I second Wilson.
I have a motion by Ms. Dryden to accept and a second by Mr. Wilson to accept the findings and facts. We'll send it to a roll call vote. Ms. Dryden,
Dryden, yes.
Mr. Wilson,
Wilson, yes.
Mr. Floyd,
Floyd, yes.
Mrs. Long,
Long, yes.
and it'd be a yes from myself. So the findings and facts have been approved as written. Okay, we're moving on to the next case, case number 2021-027.
Mr. Chair, I have a conflict on this matter, so I think the other alternate will need to step in and serve on the board here. This is John Floyd.
Thank you, Mr. Floyd. Do I have Mr. Ragu? Can you sit in on this meeting, on this case, Mr. Ragu?
Yes, sir. Yeah, lively.
Thank you.
All right, this is a transitional setback variance, and I'll give you a couple minutes to look over the findings, and if you could just let me know when you've had enough time to review.
Ms. Lisa, we can continue.
Government exhibit number 1 is a vicinity map of the property. Government exhibit number 2 is a zoning map of the property. The property is zoned B2 general business, and it's in a general business area. Government exhibit number 3 is an aerial map of the property. Government exhibit number 4 is a close-up aerial map of the property. And government exhibit number 5 is background of the request. The site is located adjacent to Albemarle Road and has an existing right-of-way of 50 feet measured from the street center line. The current zoning regulations require a proposed right-of-way of 75 feet measured from the center line. And then the 20-foot setback would be measured from the edge of that proposed right-of-way. And that would be called a transitional setback when it's measured from the proposed future right-of-way. The existing right-of-way is 50 feet from center line. And you can see in the top left where the existing right-of-way is as opposed to the future right-of-way, and the current front setback as opposed to the 20-foot transitional setback. And you can also see that the parking lot and some parking spaces and maneuvering are within that front setback area. And so since the site was developed in 1975, it's a non-conforming site. It predates the requirements for the proposed right-of-way and the transitional setback. Slide number 6 is the variance request. The applicant would like to redevelop the site and parking area. The current regulations require 25 more feet of right-of-way than what is existing. The code specifies that vehicle parking and maneuvering are not permitted in a setback, and a non-conforming structure cannot be moved unless it will comply with zoning. The applicant is requesting a variance to allow vehicle maneuvering within the 20-foot transitional setback from the proposed right-of-way. Slide number 7 is considerations of the request. Staff supports the requested variance. The hardship was not a result of actions taken by the applicants because the site was developed in 1975 and current parking and maneuvering space encroaches into the proposed right-of-way and transitional setback area. The proposed request meets the spirit and intent of the zoning ordinance because granting the variance would bring the parking lot further into compliance by eliminating the existing encroachment of parking spaces in the proposed right-of-way and transitional setback. Further, the North Carolina Department of Transportation indicated they don't oppose the variance request. Granting the variance request will not adversely affect adjacent or contiguous properties or alter the essential character of the area. Many properties along Albemarle Road have parking areas that encroach into the required and transitional setback, and you can see that on the bottom left of the screen. The variance will not impact public safety, As part of the redevelopment, the applicant is proposing to remove 2 of the 4 existing driveways that are located closest to the intersection of Albemarle Road and Farm Pond Lane. And government exhibit number 8 is photos of the property. And that's the end of my presentation. If you have any questions for me.
Are there any questions of staff at this time? Do we have anyone who's wanting to speak pro or con against this, pro or con for this case? Would anyone like to make a motion on this case?
I move to approve the variance. This is Douglas Wilson.
Dryden, I second.
Okay, I have a motion by Mr. Wilson to approve the variance and second by Ms. Dryden. We'll send it to a roll call vote. Mr. Wilson,
Wilson, yes.
Ms. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Mr. Coulter,
Ragu, yes.
Ragu, yes, and yes for myself. So the motion has passed. Now we'll review the facts and findings of this case.
I make a motion to approve the finding of facts and as written. Dryden,
I have a motion by Ms. Dryden to approve the facts and findings as written. Do we have a second?
Long, second.
I have a second from Mrs. Long. We'll send it to roll call vote. Mrs. Dryden,
Dryden, yes.
Mrs. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mr. Ragu,
Ragu, yes.
and a yes for myself. So the facts and findings have been approved as written. Next case, case number 2021-032, Carruthers Legacy Trust, represented by Mr. David Murray for the property located at 3102 Cecilia Avenue.
This applicant is requesting 2 variances to construct a single-family home on a vacant lot from the lot area and lot width. And I'll give you a minute to look over your findings, if you can just let me know when you're done.
And Mr. Chair, this is Jill Sanchez Myers. Can we specify for the record which board members will be hearing this case, please?
Yes, ma'am. Board members for this case, Mrs. Dryden, Mrs. Long, Mr. Wilson, Mr. Floyd, and of course myself as chair.
Thank you.
Lisa, we can proceed.
Government exhibit number 1 is a vicinity map of the property. Government exhibit number 2 is a zoning map of the property. The property is zoned R5, single family. Government exhibit number 3 is an aerial map of the property. You can see that the property is currently vacant. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is the variance request. The lot was created in about 1999, and the applicant believes the intent of the subdivision was to allow the existing house to be built on the adjacent lot, which measured 60 feet. So if you're looking at this survey, it would be the lot to the north. The subdivision left this lot with only 4,991 square feet in area and 39.93 feet in width. And that doesn't meet the minimum 6,000 square foot lot size and 50-foot lot width requirement of the R5 zoning district. So the lot is not compliant with zoning regulations. Since the lot was subdivided in 1999, when zoning regulations were already in place, it doesn't meet the definition of a non-conforming vacant lot. The applicant is asking for variances from the minimum lot area and width to construct a single-family home on the property. Exhibit number 6 is considerations. Staff supports the requested variance. The hardship was not caused by the applicants because the applicants purchased the property as it currently exists. The applicant's act of purchasing the property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. The applicant tried but was unable to purchase additional property for compliance with lot area or width requirement because the lot to the right is only 50 feet in width, so that is the minimum required lot width already. And the lot to the left has a home constructed approximately 5 feet from the property line. So if they move the side property line over any further, it wouldn't comply with the minimum 5-foot required side yard for R5. Granting the variance will not change the character of the area, and the lot dimensions will allow compliance with the front setback, side, and rear yard requirements. The applicant also states that the 4,991 square foot lot area is reasonable, and there are other lots in the area that have portions of the lot that are narrower than 50 feet. And if you look at this aerial to the left, you can see how many of the lots narrow towards the rear. Finally, granting the variance will not impact public safety. Exhibit number 7 is a photo of the property, and the property is vacant with some trees and vegetation. And that's the end of my presentation if you have any questions for me.
Is there any questions for staff at this time?
Lisa, is there room for a driveway when they do this? Where will the parking be?
Yes, there's room for a driveway. The lot is actually about 124 feet in depth. So let me turn it back. So can you see the lot I have my cursor on?
Yes, I see it. Mhm.
Okay, so it's about 125 feet in length.
Okay. All right. Thank you.
So Lisa, just to be clear, they're not seeking a variance from like side yard requirements. So any construction would still meet the 5-yard side yard, 5-foot side yard requirement.
Yes, that's correct. They aren't seeking any variances from the setback, side or rear yards.
Are there anyone who's wanted to speak pro or con on this case? There's no one sign up. Do we have a move for a motion on this case?
Motion to approve the variance by John Floyd.
Have a motion by Mr. Floyd on approval. Do I have a second?
Long seconds.
Have a second from Ms. Long. We'll send it to a roll call vote. Mr. Wilson,
Wilson, yes.
Mr. Floyd,
Floyd, yes.
Mrs. Long,
Long, yes.
Mrs. Dryden,
Dryden, yes.
and I, yes. The variance has passed. We will now review the facts and findings of this case.
I make a motion to approve the finding of facts as written and conclusions of law. Finding of facts and conclusions of law as written. Dryden.
I have a motion to approve the findings and facts as written by Ms. Dryden. Do we have a second?
Second, this is Wilson.
I have a second by Mr. Wilson. Send it to a roll call vote. Mrs. Dryden,
Dryden, yes.
Mr. Wilson,
Wilson, yes.
Mrs. Long,
Long, yes.
Mr. Floyd,
Floyd, yes.
and I, yes. The facts and findings have been approved as written. All right, next case is on our regular agenda, case number 2021-031. Jeffrey W. and Carol M. Montgomery, represented by Ty Schaefer, for the property located at 12317 Haymarket Road. And I understand there's someone willing to give testimony on this case.
Hi, this is Ty Schaefer. Can you all hear me? We represent the applicant. Mr. Montgomery here is with us today, prepared to give testimony in support of the variance request.
Okay, perfect. I'll go ahead and swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do, Jeff. Can you confirm for the record, please?
Okay. There's someone that signed up to speak in opposition of this case?
This is Elaine Powell, and I am not here to speak pro or con, but I do have some concerns if you'd like me to share them now.
You can share those after the case, ma'am.
Good. This is Mr. Schaefer. Just real, I'm sorry, go ahead.
Okay, and I will have to swear you in, ma'am.
I'm ready.
Okay, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter at hand?
I do.
Okay.
Okay, so if I could, Mr. Chair, I just had a procedural question. I'm not sure how you all are handling these cases in the virtual format, but I did have a question about the capacity in which Ms. Powell's participating in the proceeding today, and I would like to understand that before we begin the matter.
My capacity is environmental leadership.
Yeah, I guess.
Are you speaking as commission or as a citizen?
I guess both. I mean, I am a commissioner and I am a citizen and I represent Mountain Island Lake. And I am chair of environmental leadership. And I'm not here to speak pro or con. I'm just here to share thoughts on protecting water quality.
I do think, and it may be the case that we, deal with this later in the proceeding, but I do think there's a threshold question about whether, given the basis for Ms. Powell's participation, she has standing to appear in the action, given her explanation of the basis on which she's intervening. I don't know if we want to deal with that now, deal with that after the city presents its case and we get to that point in the proceeding. I'll defer to you all on how you want to do that.
I think probably what we'll do is we'll just go ahead and start the presentation, and then after the presentation, we'll ask if Ms. Powell would like to speak, and then we can address that with the city attorney at that time. So, Lisa.
That'd be great.
All right, I'll go ahead and begin.
Mr. Chair, I apologize, Lisa. This is John Floyd. I have a scheduling conflict at 10:30, and given that it sounds like this might take a little bit longer, I would again suggest that the other alternate handle this matter.
Okay, Mr. Floyd. Mr. Ragu, can you sit in on this case?
Yes, Mr. Chair.
Thank you, Mr. Ragu.
All right, I'll go ahead and begin. The next case is case number 2021-031. It's a watershed buffer variance. The applicant is requesting a 50-foot variance from the required 100-foot Mountain Island Lake watershed overlay buffer in order to construct a single-family home. And I'll give you a minute to look at the findings if you'll just let me know when you've had enough time.
Okay, Lisa, you can continue.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R5 single family and is located in the Mountain Island Lake Critical Area 4 watershed overlay. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property showing the 100-foot watershed buffer that covers most of the property. And there's also an existing manufactured home on the property.
Morning. Will you guys be done by 10? I have a meeting in here.
Now hold on one second, we're just having some technical difficulties.
Sorry. How long is this going to be? All right, I better check with the people who are arranging my meeting. Sorry, excuse me.
All right, sorry about that. Exhibit number 5 is background of the variance request. The lot was created in 1977, and there's a manufactured home that was placed on the property in 1975. Exhibit number 6 is background of the request. The property is required a 100-foot watershed buffer from Mountain Island Lake, and that takes up most of the property, as previously stated. The code doesn't allow structures to be built within this 100-foot buffer area. The buffer regulations were put in place in 1993 after the lot was created and developed. In 2005, the Zoning Board of Adjustment granted a variance for the property, which permitted a 48-foot variance into the required 100-foot watershed buffer with the conditions that the development comply with the maximum built-upon area allowance and that the applicant comply with the Charlotte-Mecklenburg Water Quality Department's mitigation requirements. After the variance was granted, a building permit was not obtained. The variance has since expired because the code requires a building permit to be obtained within 2 years from the date the board renders its decision. Government exhibit number 7 is the variance request. Since the Mountain Island Lake watershed buffer covers most of the property, the applicant is requesting a 50-foot variance to construct a new home. The compliant building area is shown in green, and you can see it in the lower left of the screen. So it's just a very small area that would be the compliant building area right now. Government Exhibit number 8 is recommended conditions. Staff supports the requested variance with the conditions that the redevelopment of the property comply with the maximum 24% built upon area allowance, and that an approved Charlotte-Mecklenburg stormwater services mitigation plan be put in place. The applicant has agreed to these recommended conditions. Government Exhibit number 9 is considerations. Considerations of the request are that the hardship was not caused by the applicant. The lot and existing home predate the requirements. The hardship results from conditions that are peculiar to the property because the 100-foot buffer covers most of the property, and the property could not be redeveloped without a variance. Also, the plat imposes a 30-foot setback, and that supersedes the required R5 setback of 20 feet, so that imposes 10 feet of additional depth in the front. Granting the variance will not change the character of the area. The previous 2005 variance granted 48 feet from the 100-foot buffer, and there have been 5 other variances granted for nearby properties, and you can see that over on the right-hand side of the screen. All of the properties in red are the properties where variances have been granted for the buffers. The property will be brought further into compliance by replacing the existing manufactured home, which is not permitted in the R5 zoning district, with a single-family home, which is permitted in that district. Granting the variance will uphold public safety because the applicant has agreed to comply with the 24% built-upon allowance and a Charlotte-Mecklenburg water quality mitigation plan. Also, the existing septic system will be abandoned to connect to sanitary sewer. So Charlotte-Mecklenburg water quality does support the request. Government Exhibit number 10 is the proposed rear application that the applicant, or rear elevations that the applicant has provided. And this is to show that the elevations are at character with the residential neighborhood. Government Exhibit number 11 is a photo of the property. And that is the end of my presentation. If you have any questions for me, and also the applicant has prepared a presentation as well.
I do have a quick question before we proceed. I just want to clarify, is the new build required to adhere to impervious restrictions?
Since the lot was created in 1977 and predates requirements, it's exempt from the impervious regulations of 24% built upon allowance, but the applicant has agreed as a condition to comply with those regulations.
Okay, thanks for the clarification.
Are there any more questions from staff at this time? Okay, the applicant has prepared a presentation. You may proceed with that.
Thanks very much. As I mentioned, my name is Ty Schaefer. I'm at Robinson Bradshaw. We represent the property owners in this variance request. For the very same reasons that staff supports the variance request, the same reasons that Charlotte Meck Water Quality supports the request, we think that the Montgomerys meet the standards set out in the statute and in the ordinance, and the board should grant this variance. Because we do have this on the full agenda and potential opposition or comments, we do need to create a record of the proceedings. So I'll thank you in advance for your patience as we go through this. I'm going to say a few introductory words, and then we'll hear testimony. I'll ask Mr. Spencer or Ms. McCarter, whoever wishes to speak on behalf of staff, some questions, and then you'll hear from Jeff Montgomery, who owns the property along with his wife. You deal with variances all the time, so you know the standard, but I do think it's helpful to orient our discussion today from the start. Section 160D 705 says that when an unnecessary hardship results from the strict application of a zoning regulation if the applicant makes the showings on the 4 factors that are set out in the statute, then the board shall vary the provisions of the ordinance. The factors: unnecessary hardship would result from strictly applying the regulation. That hardship results from conditions that are peculiar to the property. We look at things like location, size, topography. The hardship doesn't result from actions that have been taken by the property owner. And finally, that the variance being requested is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. If an applicant makes a showing on all 4 of these, then it's not to be a discretionary matter, and the board shall grant the variance. We think the evidence is clear that the applicant does satisfy each of these requirements. And what we'll also see, and if I could ask, I'll apologize in advance, Max and Lisa, for the skipping around, but if we could jump to applicant's exhibit 7 to start. One thing we'll also see, and Lisa alluded to this in her testimony, is that this request is squarely in line with variances granted all along Mountain Island Lake in this area. The board has routinely granted these requests, and we think it would be substantially unjust to deny what is here in all material respects a virtually identical request. This is a map from Virtual Charlotte, Charlotte GIS. The parcel at issue today is outlined in blue at the top left, the northernmost peninsula shown on this map. Each of the parcels shaded in red has been granted a variance. If we could skip ahead to Exhibit 8, please. This table summarizes the publicly available data from Virtual Charlotte regarding variances that this board has granted since 2002 in the immediate vicinity of this property. 2002 is because that's the earliest date that there was publicly available data from GIS, listed by case number, address, and tax parcel, and the variance. You'll see the average variance granted by this board is 51.4 feet, entirely consistent with what's being requested today. The Montgomerys are asking for the same thing, and so we think substantial justice would call for the board to acknowledge and respect this precedent and grant the request today. I'd like to start and maybe Ms. McCarter, if you're to testify on behalf of staff, I just have some questions to run through really briefly, if you could rejoin.
All right.
So briefly, with reference to the 2 exhibits that I just discussed, is that consistent with your testimony regarding the prevalence of approved variance requests here in the immediate vicinity of this property?
Yes, it is.
And is it staff's opinion that the 50-foot variance being requested here is consistent with that same relief that's been granted to other property owners on Mountain Island Lake?
It is consistent.
And in fact, it's consistent with the variance that already was granted to this parcel in 2005. Is that correct?
Yes.
You mentioned the property is zoned R5, so would it be correct to say that this parcel is intended to be used as a single-family residence?
Correct.
As a matter of policy?
Yes.
If we could go to Exhibit 2, please. This is an aerial from Mecklenburg County GIS Polaris with the 100-foot watershed buffer overlay, the parcel outlined in green. You testified that the structure sits almost entirely within, the existing structure on the site sits almost entirely within that 100-foot buffer, correct?
Yes.
And you mentioned also, I think that structure is legally non-conforming, right?
Correct.
So subject to the provisions of the ordinance, that structure that currently violates the buffer requirement, it can remain in place as an encroachment. Is that correct?
Yes.
Okay. would you agree that if this ordinance were to be strictly enforced, the Montgomerys are essentially unable to build a single family home on this site?
Yes, it would be very difficult.
And I think you had illustrated the current permitted buildable area. It's incredibly small, correct?
Correct.
You mentioned that the city proposed 2 conditions to the variance request, and just to confirm the record, the owner has agreed to each of those conditions. Is that correct?
Correct.
Okay, so this property will have to remain below, if the variance is granted, will have to remain below the 24% impervious area limit for the lot.
Yes.
Okay. You also mentioned, and we'll hear testimony from the owner on this same point, that the site currently is served by septic system. Is it generally in the public interest to have homes here along the lake utilize the public sanitary sewer system as opposed to the septic system?
Yes. From what I've heard, it is. Now, that's not my area of expertise, but I know that I've heard that it is.
And you indicated that water quality supports the variance request. Is that correct?
Correct. And they could not be here today because of a conflict, but one of their reasons that they support it is because of the abandonment of the septic and connection to the sanitary sewer.
Just a couple of quick final questions, and I want to direct your attention to the ordinance and section 10.508, and I believe that portions of that are excerpted in the findings of fact that have been proposed and circulated to the board. 2 questions to ask you about this. First, section 10.508.3 you mentioned does begin that no permanent structures built upon areas, septic tank systems, other disturbances of existing vegetation shall be allowed within the buffer. But isn't it correct that the ordinance then follows to say except as follows, and then outlines certain situations that contemplate a circumstance where you would have an encroachment into a buffer?
I don't have the zoning ordinance with me. I believe you're probably right, but I honestly don't have that section memorized.
Okay, yeah, that's entirely fair. So, the language, to quote for the record, this is section 10.508.3, additional buffer requirements, and it's, quote, no permanent structures built upon areas, septic tank systems, or any other disturbance of existing vegetation shall be allowed within the buffer, except as follows, colon, end quote. And then there's a list that follows that, and the one that I'm most interested in is in D, which states during new developments, the city can require enhancement of existing vegetation in the buffer if necessary, so that the buffer can effectively perform its filtering and absorption functions based on the watershed buffer guidelines. So it would be fair to say that the ordinance itself contemplates a situation where you would have an encroachment into this buffer and gives the city certain options to require mitigation of property owners in that situation. Would that be a fair reading of the ordinance?
Correct. And Ron Eubanks with Charlotte Mecklenburg Water Quality has outlined in an email his support and that mitigation would be required. Now, what the specifics of that look like is outside of my knowledge base, so I can't answer questions in regards to that.
Yeah, let me. I'm not trying to be too clever. Let me think of what I'm trying to illustrate is that this request is entirely consistent with the ordinance because the ordinance itself contemplates a situation where you would have development within a buffer, and the best evidence of that is the ordinance creates certain exceptions in situations where you mitigate that impact. Is that correct?
I believe, yes, it was trying to consider sites that were existing and may not comply, and when they redevelop, what that might look like. Certainly not for like just a newly created vacant lot.
Right. And so the variance request before you today, which asks for the ability to encroach into that buffer, but commits to revegetation to mitigate that impact. It'd be fair to say that that approach is in fact consistent with what the ordinance itself contemplates, correct?
Correct. The redevelopment of an existing non-conforming lot, and they're offering to do mitigation in compliance with the ordinance.
Okay. And you mentioned also there are other ways in which this property can be brought into conformity with the ordinance, and one of those is by replacing the manufactured home with a single-family detached dwelling, correct?
Correct. As you had said before, it's existing non-conforming before the regulations of the R5, so it could stay there. Redevelopment to a single family is a permitted use, so that is going from a use that is not permitted to a permitted use.
And that encroachment, legally non-conforming structures can be rebuilt within the same footprint per the ordinance if there is a casualty event. Is that right?
Not without a variance. Once a structure is moved that's non-conforming, you can't put it back, so it couldn't be rebuilt in that same spot.
If it was destroyed by fire, it couldn't be rebuilt?
If it's destroyed by fire, that's a different story. It's a different section of the ordinance, and it could.
Yeah, and that was my question. So that denying the variance doesn't result in the need to remove the encroachment. That encroachment will stay in place, consistent with the ordinance.
Was that a question? I'm sorry.
Yes, it is. That's right.
Can you? I didn't understand that. That was a question.
Yeah,
If
sure.
you could repeat yourself.
Yeah, I'm sorry. So we have an existing encroachment, and I want to establish for the record that denying this variance doesn't result in the removal of that encroachment. That existing legal non-conforming structure that encroaches into the watershed buffer, that encroachment can remain. Correct.
Correct.
Okay.
Yeah, it
Thanks
can
for
remain.
your patience.
Yeah, it can remain with no mitigation. So, you're redeveloping. You're going to provide mitigation. So.
Okay. Thank you. Thanks for your testimony. I'd like to ask Mr. Montgomery to join if we can. Are you on?
I'm here.
Okay. You own this property, is that correct?
Yes, with my wife.
And so you're familiar with the existing condition of the property?
Very.
And you intend to build a single family detached home on the lot, is that correct?
Yes.
And you're requesting a variance here today in order to enable you to build that home on the lot, is that correct?
Yes.
And is it your understanding that the parcel is currently zoned for use for single family residence?
Yes.
If we could pull up Exhibit 2, please. So this is the same GIS aerial that we discussed with Lisa. So your understanding is that the watershed buffer covers almost the entire property that you own. Is that correct?
Yes.
And the existing, can you tell us a bit about the existing structure on the site, what it is?
There's a double wide and a single wide that are teed together from the 70s. And they actually push very close. They're very close to the water today. And I'm looking to have them removed and put up a single family home.
If we could kind of further to that point, if we could go to Exhibit 9, please. This is an aerial from Polaris, Mecklenburg County GIS again, and the overlay here is the FEMA flood line that applies to the property. So is it your understanding that that existing manufactured home, the double wide portion, it sits almost up against that FEMA flood line? Is that correct?
Yes.
And that home is currently using septic, not sanitary sewer. Is that right?
Yes.
If we could, keeping this exhibit in mind and with reference to it, if we could go to Exhibit 3, please. This is the survey that has been was submitted by the applicant. I don't know if it's possible to enlarge that at all. Thank you. Thank you very much. I want to direct your attention to a dotted line that begins kind of at the top middle of this survey, proceeds plan south, and then curves to head across to the right. That's labeled FEMA flood fringe line. That line that was illustrated on the aerial we just looked at. The shaded area proposed new house, that's the footprint of the house that you want to build on the site, Jeff, is that right?
That's correct.
Looking at that FEMA flood line and with reference back to the aerial that we saw with the existing condition, is it your understanding that if the variance you've requested today is granted, that the home you build is in fact not going to increase the amount of the existing encroachment on the site?
Correct.
And in fact, based on these maps, it's likely the variance that you're requesting will result in less of an encroachment into the watershed buffer than that manufactured home. Is that right?
That's right. Yes.
Other than the house that you are wanting to build on the property, are you adding any additional impervious area to the lot?
No.
And have you agreed to the conditions proposed by staff that the lot will remain below the 24% impervious area, and also that you will revegetate in order to mitigate the disturbance of the buffer?
Yes.
If we could go to Exhibit 5, please. This is these are copies of the elevation. Yeah, I'm sorry. I'll wait.
Okay.
Thank you. This is a rendering conceptual of the home you'd like to build on the property. Is that right?
Yes.
Is it your opinion that that home is consistent with the other single-family homes that have recently been built in the neighborhood?
Yes.
From a safety perspective, is it preferable for you to replace the manufactured home on the site with this structure?
Yes.
When you build this home, are you going to continue to use septic system, or are you going to tie into the sanitary sewer system?
Tie into the sewer.
If we could flip forward to Exhibit 6, please. This is a document we've also entered into the record, a copy of the variance in case 05013 that was granted to this same parcel in 2005. You're correct that there were two variances granted for this parcel. One was a 48-foot encroachment into the watershed buffer, but also a 4-foot encroachment into the 30-foot setback from Haymarket Road. Is that correct?
Yes.
And so in effect, you were asking for 52 feet worth of variance at that time. Is that right?
Yes.
And you also agreed to the same two conditions that staff are requesting today, the 24% impervious area and approval of a revegetation plan.
Agreed,
Is that
yes.
right?
Yes.
I want to talk about the 4-foot encroachment into the setback. Is it your understanding that that setback is imposed not by the ordinance, but it's imposed by a recorded plat applicable to the property?
Yes.
I'll just note for the record, we've submitted that plat in Exhibit 4, and I believe that the reference to that is Map Book 18, page 111. So an identical request today to what you're asking for would have been an ask for 52-foot encroachment because the board can't vary that plat setback. Is that right?
Yes.
Are you familiar with other variance requests that neighbors in the area have filed?
Yes.
Is it your understanding that those variance requests have been granted by the board?
Yes.
And is it your understanding that the 50-foot variance you're asking for today is consistent with the variances that have been granted?
Yes.
If we could go back to Exhibit 2, please, and I'll just 2 more questions for you. I want to ask you about hardship. If the watershed buffer requirement is strictly enforced, could you build a single-family home on this lot?
No.
So you need the variance that's being requested today in order to redevelop the property.
That's right.
And it's correct that the hardship that's caused by the fact that this parcel is narrow enough that virtually the entire parcel is covered by the watershed buffer. Is that right?
Yes.
That's all that I have at this time. Thanks, Jeff. Just really quickly, if the board will indulge, because I do, for the purpose of the record, I just want to identify the exhibits that the applicant has submitted. So in addition to the slides and exhibits that were introduced by zoning administrator, we've submitted Exhibit 1, which is an aerial of the subject property that's pulled from Mecklenburg County GIS. Exhibit 2 is also an aerial of the property from Polaris with the 100-foot watershed buffer overlay. Exhibit 3 is the final survey that's been submitted by the applicant showing the variance requested and other property information. Exhibit 4 is the plat that we mentioned that's recorded at Map Book 18, page 111. Exhibit 5 are the elevations of the proposed home to be built on the property. Exhibit 6 is the variance that was granted in case number 2005-013. Exhibit 7 is the map from Virtual Charlotte showing in red those parcels in the immediate vicinity of the subject property for which a variance has been granted. Exhibit 8 is a demonstrative summarizing the publicly available information on those variances since 2002. Exhibit 9 is an aerial of the property from Mecklenburg County GIS that shows the Fema floodline overlay. And 10 is an aerial of the parcel and the immediate vicinity broader neighborhood view from Polaris with the watershed buffer overlay. But at this point, unless there are any questions from the board right now, we'll stop, return for cross-examination and closing statements, subject to, I suppose here, discussing the issue of standing before we move forward.
Are there any questions from any of the board members? Okay, Ms. Powell.
Thank you. And Mr. Schaefer, you did an excellent job of answering some of the questions that I had. And, whenever we're talking about critical watershed, we have to really think about protecting water quality. And so that's really why I'm here. So I'm definitely here as a county commissioner. Mountain Island Lake is our source of drinking water. And so I wanted to tune in, and Mr. Schaefer has addressed many things. It's nice to know the septic will be offline, connected to sanitary sewer. It's nice to know that revegetation level 2 has been recommended. I think the only question I have left is, will there be a double silt fence to prevent sedimentation during construction? Because I hear so often from constituents about their concern about sedimentation into the lake. So Mr. Schaefer's done an excellent job of answering everything, and that is, and I really want to respect the property rights of the owner of the land while making sure that we have enhanced erosion control. So my only question is, will there be double silt fencing during construction with supervision? And that concludes my comments. Thank you.
Mr. Schaefer, are you willing to?
Trying to start my video back up. So you may just get my voice. I'm sorry. I mean, I guess that may be a question if someone on staff can respond. Would that silt fencing be a requirement under code during the construction period in any event?
So erosion control inspectors will be out on site once construction begins. You could put it as a condition if the board feels like it's an appropriate condition. You could have a condition for a double silt fence.
Yeah, because unfortunately, we don't have someone here from the Charlotte-Mecklenburg Stormwater Services Department to speak on that point. But, as one of the conditions is that there would be a mitigation plan. I don't know if that would be part of that plan, or if this is something you would just the board would want to add as a condition. It may already be included, but I can't speak to that because I'm not sure.
Yeah, this is Ty again. I think my understanding is that the silt fence would be required in order to get the building permit. Mr. Montgomery's on the phone. I think I don't want to speak for him. I'll let him answer as to if he's agreeable to that condition that fencing be an additional condition. We may be able to just remove this as an issue.
Absolutely. I feel the same way. I don't want the runoff into the lake either. So that's always been my assumption, is that we'll have to have that.
Okay, are there any?
Yes, I think. Yeah.
Go ahead, Mr. Schaefer.
Oh no, I was just going to say. So I think the answer is yes. That condition is entirely acceptable.
Are there any other questions for Mr. Schaefer or Mrs. Powell?
I just want to say thank you. I think the double silt fencing will it will really help protect water quality, and I really appreciate the thoroughness of Mr. Schaefer and of the property owner. Thank you.
You're welcome. I'm on your side. I appreciate what you're doing.
Okay, does that conclude your presentation, Mr. Schaefer?
Yes, I think you've heard enough from me.
Okay. All right, we are now concluded this portion of the case that pertains to the presentation of the evidence. The board should now proceed to the discussion and decision portion of the case. Interested parties are not permitted to address the board during this portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's decision and vote. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision with the board of clerk or chairperson at today's hearing at today's hearing of this case. With that being said, we would now go into closed deliberations. Okay, board members. We are going to start, no particular order. Mr. Wilson.
Yes, I am going to be voting yes on this variance. I think that both sides were able to, in my opinion, based upon the testimony, answer a lot of questions that both sides had, and I believe that questions that some of our fellow board members may have had, in addition to the approval of the staff for us to approve this variance. I think it's pretty much okay with me.
Okay, Mr. Wilson. Mrs. Long?
I would agree. Thank you for the very thorough presentation. I'm to vote yes for the variance.
Mrs. Dryden?
Yes, my questions were answered. It looks like the homeowners are trying hard to meet all the variances, and looking at the overlays, I see where, I mean, we've granted so many other variances. It would be a terrible thing not to approve this one with the mitigating factors listed in the finding of facts. So I would be inclined to vote to approve this variance.
Okay. Mr. Pagano?
Yeah, my questions are answered and I'm good with approval. Thank you.
Okay. And for myself, again, I am inclined to agree and approve based off of, like I said, both parties have, the applicant has done everything he can to ensure that the water quality is there, and he is within the 24%. So I am inclined to approve yes as well. That being said, do I have a motion?
Dryden, I'll make a motion to approve this zoning request.
I have a
Long.
motion by Ms. Dryden to approve the zoning request. Do I have a second?
And Long seconds.
And I have a second from Mrs. Long. The zoning request has been approved. Now go through facts and findings and review the facts and findings as written, or recommend any change. Oh, I'm sorry. Let's put it to a roll call vote. I do apologize. Ms. Dryden?
Yes.
Mrs. Long?
Long, yes.
Mr. Wilson?
Wilson, yes.
Mr. Ragu?
Raghu, yes.
And a yes for myself. Again, the variance has passed. Now let's review the facts and findings.
I have one question for the attorney. Do we need to add in here something about the double silk fencing, or are we just going to assume that that's part of the regulation? I know the homeowner said he would do that. I just want to make sure that whether we need to put it in add it to the finding of facts as a staff recommendation or not. That's a question.
And was that the condition that the parties were referring to earlier? I apologize, I only half heard that portion.
Yes, Miss Sanchez Myers, that's what they were talking about, the double silk fencing to prevent erosion and the silt flowing into the watershed during construction. But the homeowner agreed to do that. And he said it's acceptable, but zoning wasn't sure that it was one of the mitigating factors when they talked about the approval of the stormwater per code section. I don't know what they, because nobody's here from stormwater to say that's yes. I mean, I have faith that the homeowner will do that. I'm just asking if it's something that we need to put in our finding of facts and conclusions.
If that is a condition that the board would like to impose, and unless there's some prohibition on including a condition like that, that staff knows of, then the board, could include that as a condition if that's your desire.
Well, board members, do you think it's something we need to even consider or think about to put in there?
Any board member have any?
I would say yes.
As we noted, the homeowner is not opposed to it, so it wouldn't be an issue if we add it to the facts and findings.
Okay, I don't know exactly where to add it though. And all we would say is that the homeowner has agreed to the double silt fencing to prevent the silt from eroding into the buffer during construction.
Could we just make it number 33? Or do we want to just add it to an additional, we would just want to add it to, I guess, one of the current findings on there?
Well, that's what I was looking. I don't know exactly where.
I guess I guess make it more easier for staff. Just add make it number 33.
That's acceptable to me, if it's acceptable to the city attorney.
Yeah, Jill, I don't know if do you agree with that? Do you think that's okay to make it number 33?
Yeah, I don't have any problem with that.
Okay, all right.
Do I have a motion to approve the facts and finding with the extra condition that we add the double silt fixing?
Okay, I make a motion to approve the finding of facts and conditions of law as amended. Dryden.
I have a motion by Ms. Dryden to approve the facts and findings. Do I have a second?
Long second.
I have a second about Ms. Long. Approval of the facts and findings with the extra condition to add the double silt fencing has been approved. But that will conclude this case.
But we got to do the roll call vote for the.
Again, I do apologize. Put it to a roll call vote. Ms. Dryden?
Dryden, yes.
Ms. Long?
Long, yes.
Mr. Wilson?
Wilson, yes.
Mr. Ragu?
Ragu, yes.
And yes for myself. Again, I do apologize. Facts and findings have been approved with the extra condition of adding the double silt fencing. Now that approved this case. Now all the cases has been concluded. We will now go into election of a vice chairperson. Do you have any motions from any of the board member on the vice chairperson?
So this is Shad. I just want to, I don't know if everyone knows what's going on, but Rick Sanderson had to resign because he is now a city employee. And so we didn't want there to be any perceived conflict of interest in any of the variance cases or appeals in the future. So since he has resigned, the rules of procedure for the zoning board of adjustment indicates that the vice chair automatically becomes chair. So therefore, Patrick Welch is our new chairperson for the board. And then what the rules also indicate is that then we will vote for a new vice chair. So whoever is a regular member, you'd have to be a regular member, not an alternate, would be able to put their name in to be vice chair. So anyone who's interested can step forward.
I would nominate Mr. Wilson.
Am I a regular member? 'Cause I can't remember.
Yes.
Okay. Yeah. Well, I will accept if nobody else is, coming forward.
Since we're all knocking down the door.
Congratulations, Mr. Wilson.
Let's see, so.
Well, I make a motion to elect Douglas Wilson as our vice chairman.
I'll
for the
second.
zoning board of adjustment.
Great. Well, congratulations. We have a motion to elect Mr. Wilson as the vice chair in a second. Congratulations. Thank you, Mr. Wilson.
All right. Thank you. Thank you, everybody.
And we got to put it to a roll call vote again. I'm sorry. All right, Ms. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Mr. Ragu,
Raghu, yes.
and yes for myself. Again, thank you, Mr. Wilson. Okay, well, next on the agenda is the approval of the March regular meeting minutes. Do we have a motion to approve the March meeting minutes?
I'll make a motion to approve the March meeting minutes.
I have a motion from Ms. Long to approve the March meeting minutes. Do we have a second?
Second.
Dryden,
Oh, sorry.
go ahead, Mr. Wilson. Go ahead, Mr. Wilson.
I have a second by Mr. Wilson to approve the March meeting minutes. Put it to a roll call vote. Ms. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mrs. Dryden,
Dryden, yes.
Mr. Ragu,
Raghu, yes.
and yes for myself. The March regular meetings has been approved. Okay, our next board meeting will be May 25th. And again, I think that concludes our business for today. Does anyone have any questions or anything to bring up to staff or myself?
I'd just like to say congratulations, Mr. Welch. You did a great job this morning.
Thank you guys for your patience. A little nervous, so I do thank you guys for being patient.
You did a great job.
Yeah.
Thank you guys. Thank you. All right, there's no other questions or concern. That will conclude today's meeting. Today's meeting is adjourned.
Thank
Thank
you.
you guys.
Thank
Have
you
a great
all.
day.
Thanks, everyone.
Bye. Have a good day.